Sir, very good evening, ladies and gentlemen, and welcome to today's webinar on Constitution and Human Rights, hosted by the Sri Venkateswara Law Students Association. It is privileged to have you all here with us today, and we are delighted to have our esteemed guest, Sri Justice Rajesh Tandon, a renowned senior advocate in the Supreme Court of India and a former judge of Uttarakhand, graces with his presence. The topic of constitution and human rights is one of great and important in our society today. And we are honored to have Justice Tandon share his expertise and insights on this subject. We believe that this webinar will provide a valuable platform for discussion and exchange of ideas among legal professionals and students alike. On behalf of Sri Venkateswara Law Students Association, I extend a warm welcome to Justice Tandon and all our esteemed guests. We hope that you will find this webinar informative and engaging. Thank you for joining us today. Now, I would like to invite my beloved lawmate, Mahendra Reddy, to speak about Sri Venkateswara Law Students Association.
Good evening, sir. Sri Venkateswara Law Students Association was established in 2022 in order to spread legal knowledge to all legal students by conducting academic activities with legal luminaries in India. Until now, we have conducted 18 webinars all over 16 national webinars and one international webinar. In national webinar, we have conducted from people of legal fraternity given their insightful knowledge on legal practice who had an eminent expertise in law. With the help of Sri Venkateswara University, Tirupati, we have conducted online legal webinars. As university law students, we are 5 years law. With our own individual capacity, had conducted legal webinars as we have got very nice response from students from different universities all over across the India. We have discussed not to just with our university, but also conduct to entire country. We have formed an association. We involved all the legal students all over the India. And so with the help of all legal students across India, we had spread our legal knowledge with the help of legal learners across India. Our motto, to learn legal knowledge from luminary expertise in the subject of law, to promote a better understanding of communication among the law students across India in the subject of law, to evolve and impart comprehensive legal education to all levels to achieve excellence. As we have mentioned already, our motto has behind do academic activities. Our only intention is to make sure that law students were equipped with the knowledge up to date. There is a difference in reading and understanding theoretical knowledge, but we need to do more than that. As law students, we have to have practical exposure of law and how things are happening at present in the court of law. We want every law student to be part of the family and involved in our work. We welcome all students to be part in the activities. Thank you. I would now request my co-host Bhavna to introduce about sir.
Good evening, one and all. So let us go in detail about the Justice Rajesh Tandon, sir. He was the former chairman Uttarakhand State Law Commission, former judge of Uttarakhand High Court at Nainital, former chairperson of Cyber Appellate Tribunal Government of India, former chairman Admission and Fee Committee of Private Education Institution Uttarakhand, former vice chairman of Amity Institute of Cyber Law and Cybercrime Uttar Pradesh, former election observer of Orthopedics Association of India. About his current designation, he is working as the chairman of Justice Rajesh Tandon Arbitration and Conciliation Center, honorary chief commissioner, Sainik Seva Council. Now going to his career, he was enrolled as an advocate on 28/3/1968, appointed as judge of Uttarakhand High Court on 3rd July 2003 by the President, appointed as Judge of Uttarakhand High Court on 3rd July 2003 by the President. He was told that during the period of his judgeship of the High Court, he used it to dispose of 40 to 50 cases per day regarding service matter, appointed as the chairperson of Cyber Appellate Tribunal by the President of India and took charge on 25 February 2009 at New Delhi. served as chairman of State Law Commission Uttarakhand in the consecutive years 2017 and 2018. Going to his diplomas, he was awarded a PhD degree from the Open International University for Complementary Medicines, Mumbai on 1st February 2015. He was awarded as the honorary professor by the MIT University on Uttarakhand on 10th November 2016. He was awarded as honorary doctorate in administrative law by AIIPPHS State of University Delhi on 26 January 2021. So, coming to his judgments, he gave many judgments on triple talaq, on human rights issues, on cyber law under the Information Technology Act 2000, environmental law, intellectual property rights, spiritual law, rent control legislation, right to food being fundamental right, constitutional law, civil law, the Consumer Protection Act 1987, Narcotic Drugs and Psychopathic Substance Act 1985, and finally, concerning educational institutions, especially on field. Thank you.
Thank you, Buna, for great introduction of our eminent speaker. Sir, we are excited and eager to hear about your expertise and experience in the field of law. Justice Rajesh Tandon, without wasting any time, I would like to invite you to take the platform and share your valuable insights with us.
Thank you very much. It's a proud to have become a part of your legal fraternity, and that too at Balaji. And I am glad that Balaji, the blessings of Balaji may be coming by online, not physically. And from your sources, I am getting it as online. Now, I congratulate the organizers in organizing the program, Mr. K. Pawan Kalyanji, Founder President, Sri V. Hari Krishna, Vice President, Sri Mahendra Reddy, Vice President, and Mrs. Reddy, General Secretary, and also Bhavana ji, who has just described me in her words so long that I don't expect. Anyway, thank you very much. Now, before beginning anything, Lord Ganesha is everywhere. Even Balaji or anywhere, Lord Ganesha, before starting any work, any lecture or anything, we just remember Lord Ganesha. Oh Lord Ganesha, one with a huge body, a carved elephant trunk, and whose brilliance is equal to billions of suns. May you always remove all obstacles from my endeavors. And I pray to the Ganesha to remove all the obstacles which are coming in the field of the students studying the law and students after completing the law going in the profession also. Now, legal knowledge now becoming a part of life, and there was a time when Code of Civil Procedure, Evidence Act, and CRPC were one of the prominent acts. Now, slowly and slowly, CPC has become a procedural law. If you have to file a plaint, you have to go by the contents of the CPC. If you have to file a written statement, you have to follow the principles contained in the written statement, amendment and all that, Order 6, Rule 17. Now, similarly for the CRPC, in criminal matters, you have to fight out the criminal matters, and the procedure has been given for penalizing under Indian Penal Code. Evidence Act is a procedure how to lead the evidence either in criminal cases or in the civil cases. But gradually, the time has completely changed. I remember the saying of Lord Denning. Lord Denning was one of the legal luminaries of the world. I think you must have heard his name, Lord Denning. He has said, for I think it an undeniable position that a competent knowledge of the laws of that society in which we live is the proper accomplishment of every citizen, man and scholar, highly useful. Lord Denning has used the word scholar also because students who are sitting here or in the word itself, they have to take lesson about the modern laws. Lord Denning has said that we must learn the laws of this society that will be helpful to the scholars. Laws of the society has completely changed, which I have said that CPC, CRPC and Evidence Act all have become a procedural law. Now, Information Technology Act, human rights, in IPR, environmental law, cyber law, all these have taken a new shape in the legal field. We are also talking of today of human rights, that is a product of 1993 Act. Therefore, my request to the students that apart from CPC, CRPC, Evidence Act, he must have a knowledge of the modern laws and which runs the society itself. Now, human rights is running the society itself on every walk of life. Similarly, Information Technology Act, that is cyber law, is also a useful for these students because daily some hacking is going on. Nobody is immune from this hacking. I have also a witness of hacking some days before when somebody has hacked my, that is mail, and and has sent the messages to all the persons by hacking from my WhatsApp and all that. And this is happening every day. Therefore, the knowledge of cyber law has become a very prominent nowadays. Similarly, take the example of Information Technology Act. That is the verdict of 2020 when the COVID-19 was prevalent. Everybody was using and taking the aid of information technology, that is online. We are also doing online today. That is the product of Information Technology Act, right from section 3, 4 and all that. That is the procedure has been given under the Information Technology Act, how this electronic evidence will work. Then the punishment has also been given right from section 66 onwards under the Information Technology Act for identity theft and all that. That is, the identity theft is being done from the Facebook itself, and therefore all the punishment has been described under the Information Technology Act. Now, third, I am coming to the human rights. In the Mahabharata, human rights have been defined as Sarve Bhavantu Sukhina in the Sanskrit language, Sarve Bhavantu Sukhina, Sarve Santu Niraneya, Sarve Bhadrani Pashyantu, Ma Kashit Dukh Bhagavate. And everybody should be in peace, everybody should be happy, and everybody should not be a sufferer of any incident or anything. That is the slogan of Mahabharata. Mahabharata has described as human rights. Now, before the human rights, that is 1993, we have got a constitutional provisions, that is Article 21 of the Constitution of India, that was promulgated in 1950. That is Article 21 of the Constitution of India. No person shall be deprived of his life or personal liberty except according to procedure established by law. This is two line, but two line has got a reference of more than the sufficient things. Now, more than sufficient things have come up in the human rights itself. That I will do before, I will read before you section 2D. Have you got any act before you? Section 2D. Now, section 2D is very important. 2D and I. Human rights means every word of it is important. If the students are hearing, they may hear it. If they have got the book, they may check it from the book itself. Human rights means the rights relating to life. Life means that has been borrowed from Article 21 of the Constitution of India. That is protection of life. That has been borrowed from Article 21 of the Constitution of India. Liberty. Liberty has been borrowed from Article 14, 15, 16 and all that. Liberty has been given there. Equality. Equality is a direct Article 14 of the Constitution of India. And main thing is, and dignity of the individual. This has been formed in the Human Rights Act, that is 1993. This has been borrowed from the preamble of the Constitution. The word dignity has been borrowed from the dignity, that is word has been borrowed from the preamble of the Constitution of India. Constitution of India says, fraternity assuring the dignity of the individual. Therefore, human rights means rights relating to life, that is Article 21. Liberty, that is Article 14 and 15. Equality is Article 14. And dignity of the individual. Dignity is the preamble of the Constitution. The entire Constitution is based on the dignity of the individual. Guaranteed by the Constitution. That is, the reference has been given to the Constitution itself, that is Constitution of India. Or embodied in the international covenants and enforceable by courts in India. Now, what are the international covenants? International covenants have been defined under section 2F of the Human Rights Act 1993. International covenants means the international covenant on civil and political rights and the international covenant on economic, social, and cultural rights adopted by the General Assembly of the United Nations on 16 December 1966, and such other covenant, this is also important, and such other covenant or convention adopted by the General Assembly of the United Nations as the central government may notification specify. What are the other notifications? You must have heard the name of Universal Declaration of Human Rights. That is the other convention. That is the Universal Declaration of Human Rights. That was in 1948. India was one of the signatories when this Human Rights Act was adopted. Now, when I will demonstrate before you what was the scientific method and what was the source for drafting this Human Rights Act, that was that there was Bill of Rights in 1791 that was in the shape of Universal Declaration of Human Rights. Then 24th October 1945, Charter of the UN was established, saying that the respect for human rights and for fundamental freedoms has to be done. Then on 10th of December 1948, the UN Charter has come when this act was adopted, that is Human Rights Act, and India was one of the signatory. On 10th of December 1948, we observed the Human Rights Day in the whole world because that was a UN conference and India was one of the signatory who adopted for human rights and ultimately drafted the Human Rights Act in 1993. And after that, much has come up. Now various laws have come up. Now various judgments have come up for the human rights. Now the human rights and Constitution, Article 21, both are related to each other. Now, when I come to the judgment of one of the judgment, that is Kapila Hingorani judgment, then the Universal Declaration of, I think everybody is aware of the Universal Declaration of Human Rights, that is of 1948. Now, the Supreme Court has said, I am citing the judgment of the Supreme Court, where the Universal Declaration of Human Rights has been described. The Universal Declaration of Human Rights 1948 enumerates at least 27 broad rights, including the right to life, freedom from slavery and forced labor. The Protection of Human Rights Act 1993 defines human rights to mean the rights relating to life, liberty, equality, and dignity of the individual, guaranteed by the Constitution or embodied in the International Covenant on Civil and Political Rights and International Covenant on Economic, Social, and Cultural Rights, which were adopted by the General Assembly of the United Nations on 16 December 1966. Means in the General Assembly, the resolution, that is Universal Declaration of Human Rights, has been adopted in 1966. The said act was made by the Parliament having regard to the changing social realities and growing concern in India, and brought about issues relating to human rights with a view to bring about greater accountability and transparency in enforcement of laws of the nation. Now everybody is aware about the laws of the society. Therefore, this law, human rights, is directly the laws of the society. That is the dignity of the individual. Main thing is the dignity of the individual. Then the Supreme Court has further said, Part 3 and Part 4 of the Constitution of India contain a large number of rights which guarantee human rights, some of which are akin to the rights enumerated in international treaties and chapters. Article 11 of the International Covenant in Economic, Social and Cultural Rights, 1966, reads, the state parties to the, this is important, the state parties to the present covenant recognize the right of everyone to an adequate standard of living for himself and his family members, including adequate food, clothing and housing, and to the continuous improvement of living conditions. The state parties will take appropriate steps to ensure the realization of his right, recognizing to this effect the essential importance of international cooperation based on free consent. Then the Supreme Court has further very important lines are there. The state parties to the present covenant, recognizing the fundamental right of everyone to be free from hunger, shall take individually and through international cooperation the measures including specific programs which are needed to improve method of production, conservation and distribution of food by making full use of technical and scientific knowledge. I may just illustrate before you, during the COVID period, the distribution of food was there. This was all in the nature of human rights. That was guided by the Universal Declaration of Human Rights, and everybody was getting the food items, grain and all that, the rice and all that they were getting. That is under the principles of human rights, which provides the dignity of the individual. That is, individual's dignity is paramount and everybody has to get food and all that. And therefore, the human rights, that is the Universal Declaration of Human Rights, provides to improve methods of production, conservation and distribution of food by making full use of technical and scientific knowledge, the principles of nutrition, and by developing or reforming systems in such a way to achieve the most efficient development and utilization of natural resources. That is, all the food and all that should come from natural resources. That is the dignity of the individual. One should maintain the dignity under the human rights, maintain the dignity under the constitutional provision, that is the preamble which has been described under the Constitution of India. These are the principles which have been. Now I am coming to the judgment of the Supreme Court, where the Supreme Court has cited some Vedas, and while referring the Vedas has said, all have equal rights in articles of food and water. And thus right to equality of all human beings has been declared in the Vedas, which are regarded as inviolable, in order to emphasize the dignity of the individual. It was said that all the brothers are the children or the children of God, and no one is inferior or superior. Similarly, they all have equal right, all equal right over natural resources, all over equality. Important like a wheel. All human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. All are equal before law and are entitled without any discrimination to equal protection of the law. That is, the Supreme Court has referred the lines from Vedas. And in another judgment of the Supreme Court has said, what does the right to food mean? Can the existence of this right to food is about respecting, protecting, and fulfilling access to food, producing resources, and work. Therefore, right to food does not make people lazy, but busy, enabling them to feed themselves. These are the words of the Supreme Court. And the students, I will just request you to kindly search on the computer the case laws on the human rights, and he will find that the human rights are connected with the Constitution of India, which at very beginning I have demonstrated before you. That is, the ingredients of Article 21 are just equal to Section 2D of the Constitution of India and the preamble of the Constitution of India. Therefore, the food has become very important nowadays. Then the Supreme Court has in some judgment has said, that is the judgment of Shanti Swarup, basic needs of man have traditionally been accepted to be threefold: clothing and shelter. Food, clothing, and shelter. The right to life is guaranteed in any civilized society that would take within its sweep the right to food, the right to clothing, and the right to decent environment and a reasonable accommodation to live in. Right to shelter is an essential requisite to the right to live, should be deemed to have been guaranteed as a fundamental right. Fundamental right is Article 14 of the Constitution of India. Fundamental right is the Section 2D of the Human Right Protection of Human Rights. That is right to life and dignity and all that. All these things are there. And students, I'll request you to go through all the laws and what are the important laws of the Supreme Court, just like right to travel. What is the judgment? That is the judgment of Maneka Gandhi. Right to privacy. That is the judgment of Khadak Singh. Right to fair trial. Police Commissioner Delhi. Torture, custodial violence. That is the judgment of D.K. Basu's judgment. Right to primary education. That is Unikrishnan's judgment. Right to pollution free. And right to harassment of working women, that is the Vishakha's judgment. Everybody knows that. These are the settled principles of the Supreme Court in these judgments, and one has to follow these judgments. And the students, I'll request you that you have no breathing time, and only they have to put hard labor in this field. In the end, I will just quote the words of Gita. मात्र कर्म अपने लिए करना बंधन है, संसार के लिए करना सेवा है, और भगवान के लिए करना पूजा है. Thank you very much.
Thank you very much, sir.
Thank you so much, sir.
Thank you so much, sir. Now I request participants, if you have any queries, please unmute yourselves and ask our speaker today. Do you have any questions? Please ask.
May I ask one question from the students?
Yes, sir.
Sure, sir.
Students, have you understood the correlation between human rights and Constitution of India?
Yes,
Of
sir.
course, yes, sir.
The the correlation, that is, what is the correlation? That is life, liberty, and dignity. These are the common in both the acts. Have you understood this?
Yes, sir.
Good. Then you will go through all these, the two acts. Have you read this Human Rights Act?
Not
Not-
completely, just gone through it, sir.
Eh? Acha.
Not completely, sir.
Acha. But you must read this Human Rights Act. What I have dictated before you, demonstrated before you, you must go through it and revise this and see the cases on human rights with constitution in the computer and all Googles and all that. You search out the cases, because this is a topic which are relevant now, day-to-day life. Yes, I'm
Yes,
now
sir.
asking it.
Yes, participants, if you have any questions, please ask.
Yes, sir. Recently, we are seeing right to freedom. Right to freedom. People are misusing that right. So many people are misusing our freedom of right. So, what are the limitations and what are the restrictions to be imposed on them, sir?
Better not to go out of the topic, because that right to freedom is a matter which is pending in the Supreme Court in various subjects and various aspects of the matter. Therefore, that is the Article 19 is there. And
Not only right to freedom, sir, but remaining all fundamental rights. I'm talking about
Yes.
all the fundamental rights.
yes, all fundamental rights. Therefore, you confine it at present to the fundamental rights, right to life, right to dignity, and all these things. And freedom, तो freedom तो है ही है. Freedom में क्या है रखा? हमें याद है 1946 में जब देश आजाद हुआ, तो देश आजाद होने के बाद ही कोई कानून नहीं था. ऊपर से नीचे से उतर के आदमी आया, दो चाटा मार दिया, उन्होंने कहा कोई कानूनी नहीं है. तो बाद में कानून आया है. तो राइट टू फ्रीडम इस तरह से न लिया जाए कि बिल्कुल ही वो इस तरह से हो जाए कि हर आदमी अपनी डिग्निटी खुद समझने लगे. जब अपनी डिग्निटी खुद समझेगा तब दूसरे को तंग नहीं करेगा, कुछ नहीं करेगा. तो राइट टू फ्रीडम ये है कि हमें दूसरे का खुद देखना है कि हाउ ही इज एंड हाउ आई एम. दैट इज माई सेल्फ डिग्निटी एंड अदर साइड डिग्निटी. you turned out to the freedom with the right of dignity. आपकी डिग्निटी अच्छी है तो आपको कोई कुछ कह नहीं सकता. दूसरे की डिग्निटी अच्छी है तो उसको भी कोई कुछ नहीं कह सकता. This is a right. You mold this right of freedom to this.
Okay, thank you, sir.
Sir, I would like to ask, what advice do you give to us law students, sir?
Eh?
What advice would you like to give to us law students, sir?
Advice.
Eh?
What advice?
Advice for the students.
Yes, sir. Yes, sir.
Yes, students के लिए मैंने एक लॉर्ड डेनिंग का पढ़ा था आपके सामने. लॉर्ड डेनिंग का पढ़ा था. लॉर्ड डेनिंग की एक बुक है, ड्यू प्रोसेस ऑफ लॉ. He has just used this word for, I think, it an undeniable position that a competent knowledge of the laws of that society in which we live is the proper accomplishment of every gentleman and scholar. That is why I have said in the very beginning that apart from the course book, you must read the environmental law, you must read the Information Technology Act and the IPR. IPR nowadays, that is the patent, copyright and all that. This has also become, therefore you need not go in the depth whether it is in the course itself or not, but you must read these books. You must have these books in your library. And then search out the cases on that point. Make a register like this, and you note down the cases on it. You just see the computer and all that. You have to read the Supreme Court cases also online either Supreme Court cases, or you get the books also in the library. And I will suggest you leave the online process. You read the book of Supreme Court cases, AIR, all that, and come to that situation that you can read the books and you will find many things which does not come online also. And cultivate this habit of reading the books, which has gone nowadays completely online, everything online, and you must read. Have you seen the Supreme Court cases ever? Not.
Yes.
Not
Yes, sir, but through online.
online. No, you read the books. You must have.
Yeah.
You
All
must
India
have you must have in the library, moot court library. You just see the books, Supreme Court cases are coming, and you read it. And when you read it, you will find many things.
Yes, sir. Please.
Okay. Thank you, sir. Thank you very much.
Just generate this habit of reading books.
Sure, sir.
My
Sir,
suggestion is, and my request is, yes.
Sir, one more question in chat box, sir. If you are comfortable with that, please answer, sir. What is the question is, what is your opinion regarding same-sex marriage? Does it comes under the fundamental right according to you, sir?
Why you are putting in a situation of that when the arguments are going on?
That's why I'm
Yes, yes.
what I mentioned, sir.
Yes.
If you are
One side and the other side, government side, Tushar Mehta is arguing the matter. When I say something, why should I come in between the court and the councils?
yeah, thank you, sir.
But my opinion is that that will not survive for more than 5 or 6 years. Maybe they may do it, but that may not survive for 5 to 6 years more.
And one more question, sir. How to start a career as an advocate?
If the husband and wife is there, both are able to seek protection of their own. That is पेशेंस में वो सब चीजें हस्बैंड भी बर्दाश्त करता है, वाइफ भी बर्दाश्त करती है, लेकिन दो आदमियों को लगा दिया जाए तो दोनों लड़ मरेंगे आपस में. सॉरी फॉर द draft the writ petition also. We will draft the Supreme Court petition also. And before arguing the matter, you must have a training before the advocate, at least for a year. And he will give you chance to speak in the court. Either you go before the district court, high court, or Supreme Court, but you must have an idea of district court also, high court also, and then the Supreme Court. Don't jump immediately to the Supreme Court. Otherwise, all these training will remain in zero. Therefore, either you go to the high court, then you will learn about the practicing and all that, that is drafting the writ petition and all that, and you join some advocate and he will guide you. And when you come to Delhi, you always come to my chamber and have the training of arbitration and all that. You are always welcome.
Thank you, sir.
If you have any queries, please ask. If there is. Okay.
I think Monica has a query. Monica, you can speak.
Advocate.
Good evening, sir.
Hiring.
Am I audible, sister?
The last question, no employment exchange is there for hiring. Up till now, it has not been opened by the government of India or government of the state, any employment exchange. If that is opened, it will be a welcome for all of you. And if I'll come to know any employment exchange, then I will let you know.
Yeah, thank you, sir. Monica, please ask your question.
Am I audible?
Yes, yes, you're
Yes.
audible. Please ask.
Excuse me. Good evening, everyone. So I have a query relating to human rights and death penalty. There is a current issue that death penalty should be abolished in order to safeguard human rights. So in this context, how can we balance out between protection of human rights and at the same time giving stringent punishment to the convicts?
फिर वही क्वेश्चन आ गया जो कि सुप्रीम कोर्ट में स्टिल पेंडिंग है. दैट इज पेंडिंग अभी वहां पेंडिंग है क्योंकि ये क्वेश्चन उठा है कि whether death penalty should be abolished or not. The bench has not been created still and the matter is pending there. But my opinion is that violation तो तब हुआ जबकि उन्होंने violation किया दूसरे को किल करके और फिर why he should be escaped. Therefore ह्यूमन राइट्स दोनों का इन्वॉल्व हो गया, कल्प्रिट का और जिसको ऑफेंडर हुआ या जिसके ऊपर बीती है, दोनों का ह्यूमन राइट्स इन्वॉल्व है. देयरफॉर तराजू में किसका ह्यूमन राइट्स तोड़ा जाए, इसके अलावा मैं इस पॉइंट पर कुछ नहीं कह सकता. एंड इट शुड कंटिन्यू. Death penalty should continue.
Yeah.
Okay, thank you, sir.
Okay, sir. Now I would like to invite my beloved Lamet Bona to give a vote of thanks on behalf of SVLSA. You are Bona, please unmute.
Sorry.
Yeah, please.
As the webinar on Constitution and Human Rights has come to an end, I would like to express my sincere gratitude to all of you for your valuable contributions and active participation. Firstly, I would like to extend my heartfelt thanks to our esteemed guest, Sri Justice Rajesh Tandon Garu, for sharing your time, knowledge, and experiences with us today. Your valuable insights and guidance have been truly enlightening, and we are grateful for the opportunity to learn from you, sir. I would also like to thank you, Sri Venkateswara Law Students Association, for organizing this informative webinar and providing a platform for us to discuss such an important topic. Your efforts have been instrumental in making this event a success. And finally, I would like to express my gratitude to all the participants who joined us today and actively participated in the discussion. Your insightful questions have made this webinar a great success. We hope to continue this engagement and learning. Thank you.
Thank you, sir. I'm certain that your words have been a great source of motivation and inspiration to our students. Your knowledge and insights are invaluable, and we are grateful for the opportunity to learn from you. We assure you that we will implement the learnings from today's session in our lives, and we will strive to apply them in our future endeavors. On behalf of SVLSA and the entire team of Sri Venkateswara Law Students Association, I would like to express our heartfelt gratitude to you, sir. Thank you for taking the time to enlighten us with your knowledge and experiences. We look forward to a long-term association with you, sir, and we hope to continue learning from your expertise in the field of law. Thank you once again, sir, for your valuable contribution to our webinar. Thank you, sir. Hope
Thank you, sir.
we'll soon in Tirupati, sir. When you come to Tirupati.
Yes, you call me, I will come for
Yes, sir.
darshan.
When you are free, sir, please visit.
Okay.
Please make a
Yeah,
plan, sir.
thank you.
Thank you. Thank you
Thank
so
you.
much, sir.
Thank you very much, sir.
Thank you, sir.